but the person is in Converse, Texas, and somebody brought him the children. I don't know who brought him the children, and he has the children at the park. Maybe that makes a difference to other people. I don't know. Does that make any difference to you, State? All right. Are y'all ready on Moody?
Yes, John.
All right. Is this still going to be a contested? Martin, this still a contested on? Oh, you're on it. Is this still going to be a contested? All right. Let's bring Mr. Moody down.
Which there's just one violation.
Yes.
There's a number of things that are alleged. Some things might be true, some might not. We're getting true to some things, not true to other things.
All right. So the only thing he has is a violation of the rules and regulations of GPS. Am I correct?
That's correct, yes, Your Honor.
And
so the question is, either he did or he did not.
And part of it is he's supposed to be like 600 feet of the residence, and he doesn't know if that's true or not.
All right. So, Vashon.
The court begins by examining whether Mr. Moody violated his GPS restrictions, which prohibit him from coming within 600 feet of a certain residence. The judge questions whether the violation occurred while he was visiting his children at a parka, detail that adds emotional complexity to the case. But in legal terms, emotions don't override conditions of release. The question is binary. Was he inside the restricted zone or not? His attorney admits there's one violation, but disputes whether everything alleged is accurate. The judge makes it clear GPS tracking isn't ambiguous. Either you violated it or you didn't. And while visiting your kids is noble, it's not an automatic defense when boundaries are breached. The state is ready to proceed and calls for the court to determine the nature of the violation. The judge presses both sides to clarify whether this is a true plea or a contested hearing. These early moments show how technical violations can quickly turn into emotionally charged debates. Even a good intention doesn't shield someone from consequences. The law is about facts. Those facts will now be examined with precision. Next.
To failure to comply with the rules and regulations of the GPS, and this is a matter of the court hearing explanations, or is this not going to be a plea true?
It's going to be a plea that the GPS rules, if I remember correctly, called for him not to go within 600 feet of the complaining witness. He did go a certain distance for visitation purposes with the children.
Well, either he was within 600 feet or he was not, and then there's an explanation. So did people believe he was
within 600 or not because he was in a park?
All right. Did somebody talk to the probation and the GPS officer to see if he was within 600 feet?
We have spoken with them, and they're going to, as a proffer, testify that he was.
All right. So they say they're going to say he was within 600 feet.
So, I mean, if that's what they're going to testify to, then we don't have a way of contesting the deal.
All right. So who's here on GPS?
Smith.
All right. Can you come forward, please? And we're not on the record. I'm just trying to get clarification. Hello. Thank you so much for waiting and your patience.
It's okay.
So here's my question. I think everybody can agree that he was supposed to be on GPS.
Yes, ma'am.
So that's.
The judge seeks clarity on whether this is a plea of true or not. The GPS condition is simple: no presence within 600 feet of the complainant. But now comes the defense. The accused was there for a visitation with his children. Suddenly, we've entered a legal gray zone where the law's rigidity collides with real-life complexities. The defense hints that while he was technically inside the restricted zone, this prompts the judge to ask, was he within 600 feet or not? Because that answer will determine everything. the GPS officer is called in to verify the facts. She confirms that Mr. Moody did, in fact, breach the 600-foot limit. That admission strips away any doubt the rule was broken. But was it intentional, or was he misled? The court now has to distinguish between an act of violation and a possible miscommunication about the visit. It's no longer just about numbers, it's about motive and setup. Who brought the children? Who arranged the visit? And does any of it actually matter under strict court orders?
100 feet
Yes, ma'am.
of the complainant?
Yes, ma'am.
All right, so is this going to be a plea of true or not true? And
True.
all right, thank you so much.
Yes, ma'am. Thank you.
We still may need you because the 600 feet, where was he located at? That's a bad question.
For
And
1 hour and
conversation.
23 minutes and 58 seconds, he was at 7460 Kitty Hawk Road, Converse, Texas. And per his condition, he is supposed to be.
The GPS officer testifies that the defendant was at 7460 Kitty Hawk Road for over an hour, well within the restricted zone. This location is said to be an apartment complex with a park, adding confusion to whether it was a residence, a neutral site, or both. The defendant may have believed the visit was permissible since it took place in a public space. But proximity is the key issue, not the setting. Whether it was a park or someone's apartment, the GPS signal placed him inside the forbidden radius. The defense's position appears to be that he was engaging in innocent parental visitation, but the judge highlights the core concern. Even if well-intentioned, the defendant violated a direct order. The line isn't flexible. This part of the hearing reflects a frequent tension in courtrooms, human needs clashing with strict legal standards. The judge isn't asking whether it was a loving visit, she's asking whether it was legally allowed. Now, the court must explore whether the complainant, possibly the other parent, was involved in setting up the meeting. If so, does that shift blame? That remains to be.
Kitty Hawk.
All right, so let me just see where Kitty Hawk is. Is this a park?
I think it's a residence.
It's a
It's an
residence.
apartment complex with a park nearby.
All right, thank you so much.
Yes, ma'am.
So you're going to come and say that he was having visitation with children or something?
Yes, with this children.
And state, have you investigated whether he was having visitation with the children?
Not specifically regarding the children, but we did investigate the fact that he breached the distance that he was supposed to be within the victim's residence and therefore violated his condition number 29.
All right, so this is what I'm trying to, yes, technically this is a violation. He's not supposed to be there. The children, one, was he actually seeing his children? And two,
The judge continues probing the circumstances, acknowledging that if the complainant invited the visitation, it changes the conversation. The key issue is accountability. Should the defendant have still declined to attend, knowing his restrictions? The state concedes that even if the children were brought to him, he had a duty to maintain legal distance for convenience, even when kids are involved. Still, the court seems to want the full picture. The judge directly asks whether anyone contacted the complainant to confirm if she arranged the visit or gave consent. Her tone implies that this detail could affect how she rules on intent versus violation. The problem lies in the clash between emotional logic and legal duty. Parents wanting to see their kids makes moral sense, but failing to observe court boundaries leads to serious consequences. The judge is walking a tightrope between compassion and compliance. This hearing shows how a GPS dot on a map can carry enormous weight, and how a father's desire to see his children could still be viewed as known compliance with bond conditions.
Anybody want to call the complainant and say, hey, did he have visitation on this day? Did you allow him to have the children at the park on this day? Because that makes a big difference to the court. It may not make a difference to anybody else, I don't know, but it makes a difference to me if he's not supposed to be within 600 feet, but the person is in Converse, Texas, and somebody brought him the children. I don't know who brought him the children, and he has the children at the park. Maybe that makes a difference to other people. I don't know. Does that make any difference to you, State?
I guess yes and no. No to the fact that he still was on notice of his restrictions, and even if someone brought him the children, he should have known that he's supposed to have stayed the appropriate distance away and maybe found an alternative location that wasn't within 600 feet of the victim's residence. But if the victim is the one who set this up.
So does anybody want to call the complainant and see if they said that? I'm sorry?
This was being as well.
Okay. Does anybody want to call the complainant and figure out how he ended up having visitation with his children at a park?
You can step under so wish.
All right, just step back. All right, thank you. All right, we're taking our break. Okay. Yeah, you got August swearing. We're taking our break though.
Agree to order, and I think my name was called while I was in another court.
And who would that be?
Brandon Diaz.
Court is calling 2024 CR 07421 State versus Johnny Ruiz Jr. Can I have parties announced for the record for the state, for the defense?
Ray Lopez.
The GPS violation hearing winds down. The judge appears disappointed that no one reached out to the complainant directly to confirm or deny the setup of the park visit. It's a detail that could have provided vital context. Instead, the court must proceed with limited information, leaving open questions about the nature of the alleged violation. The judge signals that while technical rules were broken, a more thorough investigation into the surrounding facts would have been helpful. She acknowledges that it may not matter to others, but it matters to her whether the visit was willful defiance or a misled father trying to do the right thing. After this reflection, the court announces a break. Then, just like that, we switch to a new defendant, Johnny Ruiz Jr., facing far more serious charges. The courtroom dynamic immediately shifts from parental violations to a tragic collision involving death. This transition emphasizes the wide